Welcome to Solving Citizen Legal Encounters. All right, today we have a pro se defendant in Judge Stevens' court who wants to represent himself for 2 felonies. Now, I always say pro se is not the way. We're going to go in and check this out and see how this is handled by Judge Stevens. And those of you who know Judge Stevens know he doesn't play around. Let's go.
Leo, cover.
Yes, sir.
That's you, sir. Time's come here. I think we got you ready to go. We're going to be picking a jury this afternoon. And as you know, you're charged with the state jail felony of publishing or threatening to publish intimate visual matter in 2231. That's a state jail felony. And also in 23 CR 2232 is another state jail felony of theft of property. And each of these are alleged to have occurred on or about July 30th, 2023 in Jefferson County, Texas. And it looks like the victim is, or the complainant is the same person. And you're still insisting on representing yourself.
Yes, sir.
Okay. We're going to have a standby counsel to help you, John West. But you can take care of what you want to do on your own. You just have to. That's John, who's a competent lawyer. He's going to be there for you. If you ever need to ask him something, you don't have to.
You don't have to.
The law says they're in the bullpen, ready to come out to help you if you need it. This is your life. And you've made, bless you, you've made decisions here on how to represent yourself. And very seldom does this happen, that a defendant represents themselves, but it can under the law. And the important thing is that you're completely and totally appreciating and understanding that you're held accountable, like lawyers are, to know the rules of evidence, the Code of Criminal Procedure, and the Penal Code. Those are the basic codification of laws that come into play in cases in this court, and these are where the crimes come out of. The Penal Code, Code of Criminal Procedure, dictates the way proceedings work through the process from the beginning to end, and then the rules of evidence, or the methodology of how things are presented in court. I was on the Rules of Evidence Committee that wrote these, so I'm intimately familiar and sensitive about the way this is going to follow. What we're going to do is order a jury, and we will select a jury, voir dire the jury, and you're certainly going to have an opportunity after the state goes. I go first and do an overall general set of instructions. Then the state gets to ask questions of the jury, and then you can, if you want. And then that's all for the purposes of selecting a jury, deciding which strikes you're going to use. Then at the end of the voir dire, each party gets to select their juror, select their strikes and make their strikes. And then the first 12 jurors and alternates who have not been struck will be seated right over there. And then we will swear them in and begin the presentation of the evidence with the court's reading of the rules and the instructions to the jury. Then each party gets to make opening statements, and then the state calls witnesses. You get to cross-examine witnesses. At some point in time, the state will say they rest. At that time, you may or may not call witnesses. That's your call. You can take the stand as well. But at the end of the presentation of the evidence, I will read the jury charge. The parties will make the final arguments, and then jury will go back and deliberate on a verdict. Do you understand where we're going to proceed?
No, I don't, because I haven't been arraigned. This is my first time in court. I haven't asked if I'm guilty. I'm not guilty. I haven't been read the charges. I haven't had a motion hearing on any of my motions. I haven't had you order whether I could get subpoenas for my witnesses. I haven't had discovery, which I've asked for from you. I've filed with the court clerk. I've sent the assistant district attorney the letters for it. I filed for 2 writs of habeas corpus that hadn't been heard. I filed motions to quash the indictments that hadn't been heard. I got a motion right here to dismiss the prosecution that hadn't been heard.
You've never
You
seen it?
haven't held any of my motions at all.
All right.
And here are the rules that you helped write.
Sir,
That said you should.
When I speak, you can stop.
He filed a lot of items with the court that seem to have suddenly disappeared.
Okay.
Because we can't speak over each other.
Sure. Thank you.
She's got to take everything down.
All right.
Follow those rules and don't be rude.
Okay.
Can you do that?
Yes.
All right. First thing, I thought we went over this indictment. You have no judge has ever gone over this indictment, a JP or anybody else? Do you have a copy of the indictment?
No,
Of the
I don't.
indictments? You've never even had a copy of the
It was
indictment?
on kiosk.
Okay.
It's on the kiosk
All right.
at the jail.
All right. 23 CR 2231 alleges that, in summary, that on or about July 30th, 2023 in Jefferson County, Texas, you committed the state jail felony of publishing or threatening to publish intimate visual matter. This states that with the intent to harm the complainant and without the effective consent of the complainant, you disclosed visual material, namely an electronic image depicting the complainant with her private portions exposed, and at the time of the disclosure, you knew or had reason to believe that it was created under circumstances in which the complainant had a reasonable expectation of privacy and that the visual matter would remain private. And the disclosure of the visual matter caused harm to the complainant, namely the image was posted on a public social media platform, and the disclosure of the visual material revealed the identity of the complainant, and namely that image revealed the face of the complainant and her name against the peace and dignity of the state, signed by the foreman of the grand jury. If convicted of this offense, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with now in the punishment range?
Yes, I do.
In 23 CR 2232, this indictment handed up also on December 13th, 2023, goes on to allege that also on or about July 30th, 2023, in Jefferson County, Texas, you committed the state jail felony of theft. You unlawfully appropriated property, namely jewelry and clothes and tools of a value of $2,500 or more, but less than $30,000 from the complainant, who is the same complainant as in the previous indictment we read over with you. And she was the owner of that property, and without her effective consent of that owner and with the intent to deprive the owner of the property, you committed this theft against the peace and dignity of the state, signed by the foreman of the grand jury. As well, in this case, a state jail felony carries with it no less than 180 days up to 2 years in the state jail. A fine up to $10,000 can be assessed. Do you understand what you're charged with in that case?
Yes, sir, I do.
Okay. I thought Mr. Kimler was working with you before.
No, sir, and I don't know how Kimler ever got a retained lawyer, because I did not retain him.
Wait.
I've never signed anything to retain him,
Okay.
ever, never. My signature's nowhere. I've never retained him, I've never hired him, and I don't know how he got on my case.
Did he ever come to talk to you at all?
One time,
Sir?
one time.
Do you know how that happened?
Yeah, we have jail calls where defendant's acknowledging Mr. Kimler, his attorney. He may not be very happy with him at the time, but he's on jail calls acknowledging that. I mean, he's up there certainly telling you this. Well,
thank you. He gets to speak. You don't interrupt, Mr. Interrupter.
Okay, he was just given a brand new name.
now I believe I think that was some of the confusion with the motions on it, because Mr. Kimler was representing the court. Obviously, is not going to respond to these motions when Mr. Kimmler's, representing him, while he's doing it pro se. So then,
Yeah, I to this day, I don't understand. We've had this before and I don't understand how that all happened, how that all occurred. Because read this. This is out of the file. Read that, sir.
It says, "Dear Judge Seasons, please be advised that I have been retained to represent the above referenced defendant on the docket call number 7. Please set the case as soon as filed for docket. The defendant is requesting a speedy trial." And I see his signature. I didn't sign nothing.
Yeah, but it's signed.
He didn't ask me.
Thank you. But doesn't this purport to be something Rife Kimmler?
You lied.
Something had to have transpired because a lawyer wouldn't put in work unless they spoke to someone.
Okay. Why do you think he would do that?
Sir, I don't know.
You never paid him any money, right?
No, he says he was retained.
I know, that's what it says.
He's
Lawyers,
retained.
look, I've known lawyers for 40 some odd years. They don't work for nothing.
I never.
Because it's their profession. I mean, they get paid one way or the other in some form or fashion. And some of them also donate their time, and that's what makes it a special profession because they're helping other people. But they get paid for it, or else they're out on the streets poor and destitute. I mean, it's also on this same date. He requests a speedy trial. Just that is the most bizarre thing. But you're not aware of anyone on your behalf maybe hiring him? Or
No, sir, nobody. I don't have anyone on my behalf but me. And if he's a retained lawyer, according to the law and the Constitution, I'm still able to file pro se.
and Your Honor,
Limited if I have a court appointed lawyer, but not a retained attorney.
Mr. Adams has my computer right now, but I'd probably be able to find those jail calls pretty quick.
Of course, I said he was my attorney. That's what was on the record, but I didn't ask for him. Do you have the record with me signing for him? Sir?
No, sir. You just said
Okay.
just a second ago that you never thought that he was your attorney.
Exactly.
You never had. Now you just
No,
changed your
I
mind.
said he was not my attorney.
I think he should be very careful what he says in court.
you knew he was involved in representing
And I've
something.
been filing since last year to try to get him off of it too. The motions are all filed by the court clerk. And in those motions, I specifically say that I never retained him. And that goes back 13 months now.
November 13th.
The same as I haven't had discovery. It's 21 months, my first time in this courtroom for anything like this, other than his motion to remove.
It's like I want them all.
Well, it's because someone purported to be your attorney is in charge of the representation of you according to them.
I've been set
And
9 times.
once again, you're going to interrupt all day long.
I thought
Let
you
me
was through.
speak,
I'm sorry.
Mr. Rude.
That's new name number 2.
Once again,
I
I used to get
apologize.
chastised in first grade. I
apologize.
learned.
Yeah.
Okay, I have this attorney of record, Rife Kimmler, back on 11/20 of 24 in this other case as well. And attorneys, when they purport to represent people, that's they're in charge of their representation, and that they got to be answerable for it. It just doesn't make any sense why this is happening in these cases. And of course, he's not around right now, so I can't really go into. Yeah, this one on 3/12 of 24, he requests a speedy trial in this other case as well, which it keeps getting resettings sent to him as your attorney. Mr. Boyd is sending materials to the defendant, to Mr. Kimmler purportedly. Yeah, I guess. And on 12/2, this was set on a writ hearing, and your attorney was, Kimmler was notified. And then also the state has filed a notice of intent to use at least 4 prior aggravated robbery convictions in your case. Which would that would enhance the punishment range from a state jail felony in each case to second degree.
Yes, Your Honor. I
felony
believe he's
punishment.
on parole for 120-year sentence right now or somewhere around that.
You know what? You'll get a chance, Mr. Interrupter, once again. Let him speak. You know what? You do it again, you prevent her from doing your job and you get to get held in contempt of court. I've warned you enough.
I knew that warning was getting close.
Let's not be rude.
Correct.
Okay, is he subject to an enhancement to second degree felony?
Yes, Your Honor.
I can't.
They are in sequence. There are at least 2 of those that are in sequence.
Okay. Okay. You understand, he's saying he wants to represent himself, which is fine. I'll have a standby counsel of Mr. West at trial. But can you get all this discovery over him as soon as possible?
Yes,
Can
Your
you do it
Honor.
in
We can-
48 hours or less?
Yes, sir. We can have him brought over and let him review all everything that we have.
Look, this is terrible because somebody was purporting to represent you and they're supposed to be taking care of this for you. This doesn't make any sense. This doesn't make any sense. I've never seen this before pulled, and something is, I presume, a complete total misunderstanding, because I don't know, Mr. Kimmler is not known to pull fraud at all. He's not a dishonest man.
Well, somebody is. If it's not the attorney, who is it?
This is bizarre that this has gone on this long purporting to represent you. I don't understand. And you've never seen him
One time.
one time, but he purported to say he was representing you then, right?
No, sir.
What did you see him
It
for?
was about he come and see me about the blue one being lifted on parole. And the parole was,
Why would he do that for you for no particular reason?
I don't know, somebody asked him, I guess. But it wasn't me. And parole is the whole thing behind this, just like he keeps mentioning parole. He's more concerned about my parole being broke than any evidence. There is no evidence.
No, he's not. He doesn't have a say in the parole, so he's concerned, like they all are, about doing their job that's relevant in this case. And
Yes, sir.
parole is not the point. Parole, felony, final prior convictions are the point. It's the circumstances of the crime and criminal history. That's relevant.
Yes.
Don't say it's not. It is.
I guess he figured because he's pro se, he knows what's going on.
Get that to him. This has gotten now. I'm concerned because I want him back in a week to make sure that he's got it all and he's had a chance to look at it, and because we're gonna get this thing to trial as soon as you've been languishing too long.
So can I have a question, please?
Yes, sir. Go
Are
ahead.
we gonna have a pre-trial hearing on my motions?
Yeah, we'll do that.
Fantastic.
Yeah, we'll do that. And we'll come back in a couple of weeks. Okay. We'll set it for then. Yeah, to give them time to get together. All right, that's.
The hearings on March 31st with Rife, if I can find it, you get released right.
This
For the
year.
record.
Well, I think it was, yeah, we were here at a hearing before.
Well, not.
Yeah, and that's when,
Yeah.
and that's when he was released, but I think you insisted that,
Absolutely.
yeah. And we went over the importance of understanding and appreciating self-representation, how, because that's what I would do in these cases. And just keep, anytime you want to get someone to help you, but they will stand by and be available. And it's John West, that man right over there. He'll introduce himself to you, and you can ask him any questions that you need right now if you wish. Okay, so his is reset for 2 weeks.
Yes, sir.
And it's got my foremost attention out of the 2,500 cases I've got. This one's going to fast track and make sure that you're ready and get this. We'll get this done.
2 weeks for pretrial motion.
Pre-trial, yeah, we'll do pre-trial, and thereafter we'll set it for trial. Okay, all right, that's all, sir. Thank you.
Well, that was definitely a major delay. And 2, he asked about those motions because he wants to go through that hearing first. Seemed like another delay. Now, I know he's pro se, but he has some sovereign tendencies going on, in my opinion. Let me know how you feel about that in the comments. I'm just going to follow up in 2 weeks. All right? See ya.